I'm Joel Chandler. Welcome to another episode of Unsealed. In this limited podcast series, I take you behind the scenes for an unfiltered look at various open government projects that I've worked on in the past, projects that I'm currently working on, or projects that are still in the planning stage. We also discuss various issues that intersect with open government in Florida. Before we begin, I'm not an attorney. I am not qualified, nor am I authorized to give members of the public legal advice, so I don't. What I'm sharing in this episode is based on my own experiences working on open government issues here in Florida since 2008. Today we're talking about a question I'm frequently asked. What gets agencies in trouble when responding to public records requests? It isn't technical violations of the law most of the time, and it's not because the law is confusing. It's not even because staff are malicious, although I've certainly witnessed that more than once. The real problems usually come down to avoidable mistakes, misunderstandings, or most often just the wrong attitude about what public records are and the public's right to access them. In Florida, access to public records is a constitutionally protected civil right. The Florida Supreme Court has said plainly that openness is the rule and secrecy is the exception. The 2025 Government in the Sunshine Manual makes it just as plain. The right of access is a right of the people, not a privilege controlled by the agency. If you haven't already done so, please take a couple of minutes to visit the Florida Attorney General's website and download a digital copy of the 2025 Government in the Sunshine Manual. It's a free searchable PDF and the most valuable resource available for open government issues in Florida. If you want to deep dive into the manual, be sure to check out my Artificially Informed podcast series available on YouTube. So let's talk through some common mistakes and, more importantly, how to avoid them. Mistake 1. Failing to post the contact information for the custodian of public records. This one is so basic it surprises me how often it's missed. If that information isn't posted, members of the public don't know who to contact, staff don't know who's responsible, and confusion sets in. But the risk isn't just confusion. Under Section 1, 19.1, 2, subsection 2, if the agency ends up in court for failing to provide a public record and the requester sent the demand to someone who wasn't the custodian, and you never posted who the custodian is, your agency can be ordered to pay the requester's attorney's fees and costs. If your agency does post the custodial contact information, then, in order to prevail in a public records lawsuit, the requester must direct the request to the custodian of public records and provide 5 business days written notice of the request prior to filing suit. That's a 5-day window for the agency to fix the problem before litigation. But those requirements are waived if the agency doesn't post the custodial contact information prominently on both its website and in the administrative offices where public records are routinely stored and requested. Failing to post your custodian isn't just sloppy, it's an expensive lesson waiting to happen. The fix. Publish the contact information for the custodian of public records on your website and in your offices. It's the cheapest insurance policy you'll ever have. If your agency isn't doing this, please do so immediately. Mistake 2, being curious about the requester. Agencies sometimes act like they have the authority to play detective, asking who the requester is, what they want the records for, or what their motives might be. Let's be clear. You don't have that authority even if you have a gun and a badge. The requester is not required to disclose their identity or explain the purpose of the request or show some special need for the records, and there is no citizenship requirement. The only thing that matters is the request itself. Think about it this way. If you're at Publix, the cashier doesn't ask why you're buying bacon before letting you pay. If you're voting, the poll worker doesn't demand to know who you're voting for before handing you a ballot. If you walk into a church, a cop doesn't have the right to stop you and ask you to justify your faith. Asking for a public record should be as uneventful as paying for groceries at Publix. If it's something more than that, you're doing it wrong and need to change your agency's culture. When agency staff get curious, it's not just unhelpful. It comes across as intimidating, potentially unlawful, and super creepy. The fix: keep it professional and neutral. Only ask questions if you need to clarify the request. Anything else isn't just off-putting, it's none of your business. Mistake 3. Unlawful fee demands. Agencies sometimes use fees as a means to frustrate access to public records. That's not speculation. More than once, I've found extensive email conversations between public officials conspiring to frustrate access to public records using unjustified and illegal fees. An agency may impose a fee if the nature or volume of the request require extensive use of information technology resources or extensive clerical or supervisory assistance by personnel of the agency involved, or both. Then the agency may charge, in addition to the actual cost of duplication, a special service charge, which shall be reasonable and shall be based on the cost incurred for such extensive use of information technology resources, or the labor cost of the personnel providing the service that is actually incurred by the agency or attributable to the agency for the clerical and supervisory assistance required, or both. Simply put, if fulfilling the request requires substantial agency resources, then the agency may impose a fee that is based on the use of agency personnel. But those fees must be based on actual costs. Public records access may not be used as a source of revenue. Here's where having a written public records policy comes in. A well-written policy will state that if a request takes more than a certain amount of time, a special service charge will be imposed. Some agencies set that at 15 minutes, some at 30, and some as much as 2 hours. Whatever time your policy specifies, it should be imposed uniformly. What counts as extensive must be reasonable and based on actual cost, not imagined inconvenience. Demanding unauthorized fees for the performance of a non-discretionary ministerial duty, like providing access to public records, sure feels like extortion. Read Section 836.05 of the Florida Statutes and give that some thought. Fees for accessing records should be imposed reluctantly and only when absolutely justified. If your agency is imposing fees in response to most requests, or if the fees are imposed haphazardly, you're doing it wrong and inviting litigation. The fix: publish your fee schedule, train your staff, don't improvise. Only charge fees if it is necessary and impose fees consistently. Mistake 4. Unreasonable delays. Agencies often think reasonable time means whenever we get around to it. It doesn't. The statute, Section 1, 19.07, subsection 1A, says records must be produced at any reasonable time under reasonable conditions. The manual emphasizes the same point. Production must be prompt and without unjustified delay. Courts have enforced this strictly. In Daniels v. Bryson, the third DCA said withholding a record inflicts an irreparable injury on the requester. You can't give people back yesterday's right to know. The fix: how long does it take you to stop what you're doing? Go find the records, review them for valid exemptions, collect statutorily authorized fees, make redactions, and produce copies. That's how long reasonable is. Courts are not patient with excuses like we were busy or we don't like this requester. Mistake 5. Treating requests as a nuisance. This one is about culture. The statute, 119.01 subsection 1, says flatly, "It is the policy of this state that all state, county, and municipal records shall at all times be open for personal inspection." If your staff see request as an interruption, or worse, if the goal is to make the process so unpleasant that the requester gives up, you're not just breaking the law. You're undermining public trust, inviting lawsuits, and setting your agency up to be a headline. The fix: reframe the mindset. Every request is a citizen exercising a constitutional right. Serving them isn't an interruption, it's the work. Mistake 6. Withholding records is a crime. This is the most serious of all. Agencies sometimes think that delaying, hiding, or otherwise withholding records is just part of the back and forth of responding to requests. It isn't. Florida law treats it as both a crime and an injury. Under Section 838.022, a public servant commits official misconduct as a third-degree felony if he or she knowingly and intentionally obtains a benefit for any person or causes unlawful harm to another by concealing, covering up, destroying, mutilating, or altering any official record or official document. And yes, that includes public records. And the courts agree. In Daniels v. Bryson, 548 Southern 2nd, 679 Florida 3rd DCA 1989, which I mentioned earlier, the court held that unlawfully withholding a public record inflicts an irreparable injury on the requester. Concealing or covering up a public record from a member of the public seeking access to that record inflicts an irreparable injury. It also violates that person's constitutionally protected civil rights. The fix: train staff that withholding is not an option. If an exemption applies, cite it. If not, produce the record. So how do agencies stay out of trouble? Designate and post your custodian. Don't interrogate the requester. Stick to lawful fees. Respond promptly. Remember, access is a duty. And never conceal or withhold records. The Sunshine Manual isn't your enemy. It's an invaluable resource. It gives you the guardrails to avoid lawsuits and the confidence to know you're serving the public the way Florida law intends. Most of the trouble agencies face with public records doesn't come from complicated legal puzzles. It comes from simple mistakes you can avoid. And here's my invitation. If you're listening to this and you work in government and you want help walking through these issues, reach out. I'm happy to set up a Zoom meeting at no cost to talk about how your agency can improve its open government customer service experience. I'm Joel Chandler. Thank you for listening to another episode of Unsealed. Remember, the truth dies in the dark.